Do you think you're being punished at work for speaking up about a legitimate concern? Do you think you might be a victim of workplace retaliation, but you don't know how to prove it? Today, I'll break down what retaliation looks like, how to prove it, and the landmark Supreme case that changed workplace protections for all. And stick around until the end because I'm going to share 5 signs you can use to know if you're being retaliated against. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. On this channel, I talk about real legal cases that demonstrate how the law might apply to your circumstances. Retaliation isn't always overt, which can make it very difficult to pinpoint. Today's case is an example of retaliation that was apparent to the employee but could have easily been misunderstood as something else. Let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. Don't forget to like and subscribe. This case starts with Sheila White, who worked as a railroad track maintenance employee at Burlington, Northern, and Santa Fe Railway Company in Tennessee. Sheila was with Burlington for about 3 months before she filed a complaint of gender discrimination. She was hired in June of 1997 as a forklift operator, and she was the only woman in her department. She filed a complaint in September of 1997 and made the allegation that her supervisor made sexist remarks about her and to her, and that she was being treated unfairly compared to her male coworkers. Sheila was the only woman in her department, so this complaint really stood out. After Sheila made the allegation about specific incidents of alleged sexual harassment, her supervisor removed her from the forklift position that she was working and put her in a new position. Now, her pay and benefits remained the same, but her new job was more difficult, dirtier, and just harder overall to perform than the forklift position. And a few days after Sheila filed the charge alleging sex discrimination and retaliation, she was also suspended without pay. She was reinstated after 37 days with back pay. Now, the supervisor said in court that he removed Sheila from the forklift operator position due to seniority. She was the least senior person on the team, so she would not be able to work the forklift because she was not the most senior. What do you think? Was the supervisor telling the truth?
You lie, you lie.
That's right. The supervisor was lying. And fortunately for Sheila, the court saw right through the lie and they ruled that both the suspension and the job transfer were retaliatory. Laws can mandate equal pay and a workplace free of harassment, but no law can change a person's heart. When biases exist, they inevitably shape how women are treated at work. And that's the reality many women still face today. If you want to dive deeper into this issue, check out my video, Gender Discrimination Lessons from Twitter. But for now, back to this case. The court found that the reasons given by Santa Fe Railway Company as legitimate reasons for what happened with Sheila were in fact false, and they were nothing more than a pretext for unlawful retaliation. And this company, Santa Fe Railway, they would not stop. When the ruling originally came in favor of Sheila, I mean, it was obvious that there was retaliation. I mean, it was very clear that even though it wasn't as overt as a termination, retaliation had occurred. But the employer, Santa Fe, continued to appeal the decision until it went all the way to the Supreme Court. And ultimately, the decision was made in Sheila's favor. The jury had awarded her previously $43,500 in damages on the retaliation claim, and the Supreme Court ruled that she was entitled to receive it. Retaliation happens when an employer punishes an employee for engaging in a legally protected activity. And a few examples of legally protected activities are reporting discrimination or harassment, just like what we're seeing in this case with Santa Fe Railway and Sheila. She reported a claim of harassment, and shortly thereafter, her job was changed. So that was a legally protected activity that resulted in a claim of retaliation. Whistleblowing is also especially whistleblowing on an illegal activity, because that's really what it has to be. If you're just talking about something that isn't a violation of the law or your internal policies, it doesn't matter. It doesn't really protect the activity. But if it's an illegal activity, then that is protected. And if you experience an action by your employer that's in punishment of that, that could be a retaliation claim. Filing an EEOC complaint. This is why it's okay to file an EEOC complaint while you are still employed, because if your employer were to take action against you because of that, then that's a retaliation claim. Participating in a workplace investigation is also protected. This isn't just if you file a grievance, this is also if you are a party to the investigation, meaning you are named as a witness or you're just someone who told the truth about what you heard or what you saw. That can also be a protected activity. And if an adverse action, if there is a punishment taken against you, then you could have a retaliation claim. Asserting a workers' compensation claim due to your injury, something that happens to you at work, you file a claim and then there's an action taken. Workers' compensation is a protected activity. And then requesting accommodations due to your own disability, your pregnancy, or religion. Those are all protected activities as well. This is just a short list because I wanted to share a list to give you an idea of what retaliation looks like, but there are many other ways that it can happen. A key factor in proving workplace retaliation is something called temporal proximity. Basically, it's how fast the punishment comes after an employee speaks up. It's a review of the time gap between an employee's protected activity that we just reviewed, like filing a complaint, whistleblowing, or requesting an accommodation. It's a review of the time gap between that activity and a retaliation action that's taken by the employer, like a demotion, a termination, or increased scrutiny about the job that's being done by the employee who filed the complaint. In legal cases, the shorter the time gap between the complaint and the punishment, the stronger the inference that retaliation occurred. And courts take timing very seriously in these cases. It's a key factor in determining if retaliation was present in what an employee experienced. Sheila White filed her complaint in September of 97, shortly after she was reassigned to a less desirable position and then later suspended without pay. So there was temporal proximity between what Sheila experienced and the adverse action that was taken against her. One thing to remember is if there is a pattern of negative treatment over time, meaning it didn't happen as quickly as what happened with Sheila, but you can demonstrate that over a long period of time, there have been a series of actions that have been taken that essentially support a claim of retaliation. The courts can still find a retaliation claim is legitimate. What they are looking for is cause and effect, meaning the complaint made by the employee likely triggered the employer's adverse action against that employee. There are three exceptions to protected activities that you exercise that could result in retaliation. I want to review them with you now. If you have a performance discussion that began prior to the retaliatory behavior, meaning if you file a complaint, but your employer has been in discussion with you about your performance, and you consider that ongoing discussion about your performance that happens after you file a claim as retaliatory behavior, it is not. So that would be an exception to the temporal proximity rule that we talked about, because those performance discussions happened well before you filed your complaint. The second one is an exception is violation of policy. If in fact you violate policy after you file a complaint, a grievance, you should still be held accountable for that a violation. Now, it does depend on the type of violation it is. I would say if it's a severe violation, your employer has to hold you accountable for it. If it's a minor violation of policy, they might address it without, proceeding with a written warning or something like that. But a violation of policy does introduce an element of, okay, is this really retaliation when the employee does not have clean hands. They participated or did something that caused the employer to respond in a punitive manner. And then the third one is if there is a restructure or reorganization that's completed in compliance with federal and state laws, because restructures are due to business necessity. And if you are impacted by a restructure or a reorg, and there is a legitimate reason for that, more likely than not, the legitimate reason is going to involve expenses, budgetary constraints, and or an impact to the entire department or the company, not just to you. If that occurs, then that would be an exception to the claim of retaliation due to participating in a protected activity. Over the years, I've seen workplace retaliation take many forms, but these five warning signs come up again and again. If any of these happen after you file a complaint, it could be retaliation. I know I touched on this earlier, sudden negative performance reviews, but I wanted to highlight it in the top five, especially for long term employees who have consistently performed well. If you've been at your job for years with positive reviews, and suddenly after you've engaged in a protected activity, you start receiving negative feedback that's inconsistent with your past performance, that's a big red flag, especially when there's no documentation to justify the change. It's just a strong indicator of workplace retaliation. Sometimes work relationships can feel like bad romances, right? You ignore the red flags, you blame yourself or convince yourself that what's happening isn't real. And increased scrutiny or micromanagement can be one of those things that make you feel that way because you can't do anything right. If you find yourself under constant surveillance with your boss nitpicking every little thing you do after you have engaged in a protected activity, then it could be retaliation. It's important to understand the difference between a significant mistake and a minor one. And sometimes that can be hard to distinguish when you are under such close scrutiny. But a significant error is obviously something that has or could have serious detrimental consequences. A minor mistake doesn't have detrimental consequences. So if you're being micromanaged over small, inconsequential issues, ask yourself, is this normal or is this retaliation? Next on the list is a reduction in pay, hours, or assignments. And this is one of the most direct ways that an employer can retaliate against you because they're hitting you where it hurts in your paycheck. And what happens is, you were on a full time schedule. Now your hours are cut significantly. You're kind of working part time hours. No one's telling you why. You were earning bonuses and commissions. Now you're no longer earning bonuses and commissions, or that major project has been reassigned to someone else. And this is especially true if these changes happen after you have participated in a protected activity. The question comes up often, though, is can't employers change your duties? Can't they modify your hours? Well, yeah, of course they can. Companies can make business decisions about operations, and needs of operations change. They're fluid. But there's a difference between a legitimate business need to make a change and a targeted punishment. And I think that's what we saw in the case we reviewed today, where they gave some flippant reason about, seniority, but that wasn't the case. It had nothing to do with seniority. authority. Sheila was driving the forklift before she filed her grievance. After she filed a grievance, all of a sudden she couldn't drive the forklift anymore. So the key question that you have to ask is this happening to just you? Are you the only one who's being impacted by this change? Or is it happening as a direct result of you speaking up? Next up is exclusion from meetings, projects, or key decisions. Now, this type of retaliation can be very subtle. It's one of the most damaging ways an employer can undermine an employee after they speak up. So, let's say, for example, you've always been included in important meetings, but now you can no longer participate in them. And then you also have been a key contributor on different projects, but now you're left out of those discussions. Decisions that used to involve you are now made behind closed doors and you're not allowed to participate in them. The question you have to ask yourself if this is happening to you is why you're being left out. If there's a clear business reason, that's one thing. But if the exclusion starts right after you report an issue and only you are being affected, that's a red flag for retaliation. The last major sign of workplace retaliation is harassment, hostility, or exclusion. When employers or coworkers create a hostile environment after you have spoken up about something that concerns you in the workplace, that's a protected activity. That's not just unfair, it could be retaliation. So let's say if your boss or coworkers start treating you differently, giving you the cold shoulder, or making sarcastic remarks about you, your work, spreading rumors about you, and you're suddenly isolated. And people who used to collaborate and work with you, they avoid you or they stop including you in conversations. Your manager singles you out for criticism in front of others, sets unrealistic expectations that weren't even an issue before. And so you are experiencing a whole host of things that you didn't before you exercised your right to participate in a protected activity. And this is the type of thing that you can, physical intimidation, raised voices, aggressive emails, being ignored completely. This is the type of thing to remember that retaliation isn't always about losing your job. It's also about making the workplace so miserable that you feel pressured to leave. So you believe that you are experiencing retaliation. What should you do? The first thing you're always going to hear me say on this channel is to document everything. Documentation is so important when you're talking about retaliation, not only because of temporal proximity, but also because these types of things can go on for an extended period of time and gradually happen, not be an immediate outcome that sometimes happens, like what happened with the case that we saw today with Sheila. So, documenting everything is so important. Keeping those records of emails, conversations, and performance history that you've had, your own records, is critically important. So that's the first thing I would say to do. The second thing is to get out your employee handbook, look at your company policies, and understand what the company says your rights are. I'm always going to encourage you to report the issue to HR if it is safe to do so. You know the type of company you work for, you know the type of things that have happened when people have raised issues in the past. If you feel like it's safe, please report it to HR. They are there to help you resolve your issues. File an EEOC complaint if this is happening and it's within 100 to 300 days that you experience the adverse action, because that's about how much time you're going to be given to file a complaint with the EEOC. And then, of course, seeking legal advice is always important if retaliation continues, because an employment lawyer can look at the facts of your case and can align whether or not discrimination has, in fact, taken place. I'm actually going to be sharing a workbook that you can use to help you determine if you have experienced workplace discrimination as it relates to retaliation. If you would like a copy of that, make a comment uh, in the comment section. I'm happy to send it to you. Retaliation happens. It can be subtle or overt, but it's more common than you think. The important thing is to know that you don't have to go through it alone. I hope the information I've shared with you today is a help to you as you try to figure out what is the best course of action. If you've experienced workplace retaliation, I'd love to hear your story. Comment below and don't forget to like and subscribe for more workplace insights. I'll see you in the next video.